Louisiana is a community property state, and if you do not have a prenuptial agreement which gets rid of the community property regime, then there is a very strong presumption that exists that everything that was acquired during the marriage and that exists in the possession of the spouses as of the filing of the divorce date is in fact community property. Separate property is essentially things that you bring into the marriage, whether it be cash, a house, a car. Those things will remain your separate property unless they become commingled with community property. Separate property also consists of things that you inherit during the marriage or things that one spouse receives as a gift during the marriage. Upon termination of the party's community, which is generally, but not always, the date of the filing of the petition for divorce, all of the property that the parties have that's considered community property has to be divided. And that includes assets as well as liabilities. And the property has to be divided equally. Everything will be divided, including bank accounts, brokerage accounts, retirement plans, real property, automobiles, furniture, and if the parties cannot agree on an allocation of those assets, the court will make an allocation. The division of property in Louisiana can be greatly affected by what are called reimbursement claims. The most common type of reimbursement claim is a claim where one party uses his or her separate property to acquire something like a house that becomes community property, but much of the funds were used or came from separate property of one of the parties. In that situation, upon the division of the assets, the party who used the separate property will be entitled to reimbursement, and all those reimbursements will have to be thrown into the mix of determining who gets what at the end of the marriage.